Your side mentioning except chamber matters.
But 48 will not. The witness is recovering from the illness, my lord, but complete recovery has not been made. Another, my lord, only 45 days, my lord, time would be
Item
given.
48.
Item 48, my lord, Swadeshi Merchants Private Limited versus Punjab
The
National.
suit was pending for witness action.
My lord, no, this has come under the old suit hearing, but my lord, it will be. I will be praying on that day. On the next day, will come that immediately the hearing be started because of the fact my witness is recovering now. There are only 45 days time. Last time, my lord,
Yes, record an order. Mr. Chakraborty, learned advocate for the plaintiff, submits that the witness of the plaintiff is suffering from ailments and about 45 days time be given to recover and to depose in this matter. Thus, this case stands until 10/9/2025,
my lord.
10th of September 2025. Under the heading witness action,
My lord,
under the heading witness
my
action,
lord. 10th of
September.
September. My lord, I'm extremely grateful, my lord.
May I have your lordship's leave to mention a matter? May I have your lordship's leave to mention a matter? This is a suit which was scheduled to appear on the 22nd of July for hearing of Order 7, Rule 11. So
Yes.
yesterday was 22nd of July. It has not been listed. I appear for the plaintiff.
The application is this? Order 7, Rule 11? Okay.
Dependent number 1.
So let this application appear.
Your lordship will fix it tomorrow or day after because it was due yesterday. It hasn't been listed.
May I have your lordship?
Okay, let it appear under the heading to be mentioned first. Thereafter, date will be fixed. Yes, to be mentioned.
The martial matter, the interim order is about
It appear tomorrow as to be mentioned, your lordship?
Tomorrow has to be mentioned.
Right. I'm deeply obliged.
martial house matter.
Yes, it will appear as to be mentioned probably tomorrow. I've already fixed it. The matter was mentioned.
They have perhaps mentioned without notice.
Yes, to be mentioned. It will appear tomorrow.
Lord,
Tomorrow.
may I, Lord, have your lordship's kind leave, Lord, to obtain a leave, Lord, to file an execution without, Lord,
With the short cost title.
without the copy of the decree. Lord, judgment is there. Lord, I've applied for the decree, but the drawing up of the decree is taking some time.
So what is the urgency?
The urgency, Lord, the money is required, Lord. Money is to be withdrawn. That is required.
How long will it take for the decree to be completed?
Last, 3 weeks, Lord, the decree is taking
Just
time.
wait for some time. Okay, just wait for some time.
May I have your lordship's kind leave to mention, my lord, one suit of 2014, my lord. I am for the defendant.
Yes.
My lord, written statement was filed in 2015, my lord.
Yes.
The plaintiff is not taking any step. I am mentioning upon my lord. Made this suit appear any day, my lord, as per your lordship's time.
Okay, let it appear in the usual course. Serve a notice upon the plaintiff.
I have served notice.
Okay, let it appear.
May I have your lordship? May I have your lordship
Just-
and leave to mention one matter, very old probate matter in the year 2002. The probate was granted. Subsequently, my lord, that grant was revoked by the appeal court. And after, with the direction upon that test executor to serve citation upon my client. He was one of the beneficiary of
The
that.
matter is to be reheard.
But my lord, 22 years already passed, my lord. The priest of that family whose favor the probate was granted, he was enjoying the property, my lord.
Let
We
it
are
appear. You
depriving.
serve notice. Let it
Sir,
appear.
I have served, my lord. They have deposed, and that is only or already on record, my lord.
Okay, let it appear.
And my lord, the earlier bench was called for the record from the department, your lordship, and they have already filed the report to the court also.
So let it
Let it
appear.
appear tomorrow, your lordship.
Let it appear in the usual course. Okay.
My lord, we can application for restoration of
Yes, give the
restoration
slip.
and restoration. The old suit 2011 and application for restoration and condonation
Yes,
of
it will
deed.
appear.
Grateful, my lord. In the usual course, my lord, in the usual
Yes, sub notice
I
also.
already served. Okay, grateful.
Your Lordship, may I be kindly permitted to mention a matter, CS 245 or 2001. The matter is running in the warning list. Your Lordship kindly includes it in the list. for
Okay, keep
further
the slip, it
direction.
will appear. Sub notice upon the other side.
It is served, Your Lordship.
Yes.
Lordship, this matter is treated as CAB.
Yes.
CAB. This matter is treated
Yes,
as
give the slip.
Any other mentioning? More orders, item number 4.
Yes, I'm reading out the operative portion. Hence, it is ordered that the results of the elections held in terms of order dated 3rd April 2025 passed by Honorable Justice Vivash Patnaik stands confirmed. Sri Dash Dash are appointed as joint special officers at so-and-so remuneration to be paid by the trust. Learned special officers shall forthwith fix a date and time when the newly elected committee will take over charge from the previous committee and communicate the same to the applicant and their learned advocates. Such handing over charge shall be in presence of the learned special officers. Learned special officers shall ensure that accounts of previous year and relevant records are made ready at the time of making over charge. Learned special officers pursuant to taking over charge by the new trustees hold meeting with the present Shabites within 2 days. Upon holding the meeting with the present Shabites and considering their suggestions or grievance, if any, made by Shabites, hold a meeting with the board of trustees within 2 days thereafter, communicating the grievances of Shabites for doing the needful, so that the Devattur estate can be better administered in accordance with the letter and spirit of the scheme framed by this court. Learned special officers shall submit report on 6/8/2025. It is needless to mention that this order is also to abide by the order of the Honorable Appeal Court. Fixed 6/8/2025 for submission of the report.
But not only thing, your lordship is directing that the special officer
In whose presence the charge shall be taken
charge
over.
shall be taken over. Account
Thereafter, yes, entire thing he should ensure that it is done.
and your lordship is that he'll file a report before your lordship.
Yes, after holding meetings with the Shabites and the new committees, and thereafter he will submit a report.
Your lordship is fixing 2 persons to be the.
Yes.
Your lordship is fixing 2 persons to be.
Yes, 2 persons from the bar to be the special officers.
Hand over.
No, it will appear for report.
One more thing, I think it is if lordship sees Justice Patnaik has had appointed Justice Jyotima Bhattacharya as the.
That is for Commission of Election.
Yes, everything.
That is over.
No. Normally, what happens is, I'll tell you, lordship, he was given a remuneration also. He has refused to accept that. Would your lordship order put in a line that your lordship has expressed gratitude that he has carried out the work extensively because he has worked a lot.
Yes, it's definitely okay. I'm just adding one line.
Will add a line. No, not just now. Your lordship at your.
Yes, definitely.
That he has.
Yes.
Humble job and not taken any remuneration.
Yes, last line it will be added, and with due respect, this court discharges his lordship. That will be added.
That was there. And this, your lordship is fixing after all this, they will come back to your lordship on
6th of August.
6th August. No, which is special, another special officer.
Or some more date is required, some more time is required.
No.
6th of August is the reason.
Your lordship, may I say something? Would your lordship appoint the chairman only to hand over and do this, or would your lordship appoint someone?
No, I'm just appointing 2 from the part. Okay. And so for chairman, I'm discharging him with some appreciation. Yes. Because his lordship's function was still holding up the elections.
Because we've never had this special officer handing over in the past.
So you see, there are so many allegations, counter allegations. Let something be done. Yes. No, to be mentioned.
When do we?
Okay.
Do we mention item number 1?
Order will be uploaded.
My lord, I am appearing for the applicant in this matter. My lord, on 3rd of July 2025,
Yes,
my lord,
special officer was appointed.
special officer is present. My lord, a copy of the report be handed over to us.
Yes, copy be handed over. So the direction was, I think, to find out who is in possession
Yes.
of this property.
My lord, the special officer has indicated in his report
Yes.
that the appellant is in possession of the property.
Applicant.
Is in possession of the property through his tenant.
That is clause 1.
My lord, it's in second page, first paragraph.
Middle. Second page, first paragraph. So anyway, so
my lord, in this
the
event,
possession is confirmed.
My lord, in this event, I am praying for prayer B and D. My lord, the special officer may execute the deed.
Yes, I shall pass it on the next day. That order I shall pass it on the next day. Yes,
lord.
record an order. A learned advocate for the applicant. Yes, you are representing which party?
Defendant number 10 Millards.
Yes, learned advocate for the applicant and learned advocate for the defendant and learned special officers are present. Learned special officer submits a report. Let the same be kept with the record. Upon perusing the report, it appears that Mr. Sanjay Kumar Lodha, the applicant herein, is found in possession, under possession through tenant. Stop. Let this matter appear for orders, final orders on 30th July 2025.
Obligation. My lord, only one thing, the name of the applicant is Sanjay Kumar Ladha.
Sanjay Kumar?
Ladha.
No, in the special officer's report, it is mentioned as LADDHA.
My lord, LADDHA.
Not Lodha.
Not Lodha.
LADDHA. Okay, final orders will be passed on 30th of July.
Much obliged.
এক মিনিট, জাস্ট মিনিট, এটা তাহলে 30 তারিখ, হ্যাঁ, এটা এই রেকর্ডটা তাহলে পাঠিয়ে দেবেন। 21 ফিক্সড আছে 10:30টায়, তাহলে ডেকে দিন।
Item number 21.
I am for the defendant, my lord.
Dr. I appear for the plaintiff in this matter. Your lordship had directed the defendant to serve a copy of the reply within 2 weeks by an order dated 30th of June. That reply, your lordship, we have received day before yesterday.
Which application? GS6?
GS6.
My application, my lord. At the instance of the defendant, the application is being filed, my lord.
No, GS6 is your application?
Yes, my application, my lord. Reply has already been served, my lord.
So you received the reply by
We have received the reply. I'm requesting your lordship to kindly fix the matter next week on Tuesday. On that day, your lordship, the matter can be heard.
Let this matter appear on 30th July 2025.
Lordship, 30th, there is some difficulty. Actually, I'm led by Mr. Kaur.
Okay. 29/7/2025. এই 12:30 কোনো ম্যাটার ফিক্স আছে? দেখুন তো 29 তারিখে।
12:30 ফিক্স হচ্ছে।
29 তারিখ হবে না, চেম্বার ডে, 12:30 হবে না, দুটোই ফিক্সড আছে। 29 তারিখে দুটোই, বা 4টে কি 3টের সময়? 4টের সময়। Okay, at 4 p.m. on 29th.
Obliged.
Item number 2.
Item number 2, I am one of the trustee of the trust Chimanal Bhartiya, your lordship. On the last occasion, there was a direction upon the register to furnish a report with regard to the CIS system because the cost title is not matching with the number of the PLA, your lordship. PLA
This report must be
102A
here.
of 93, but it is appearing as PLA 102. Your lordship called for a report for the register to change the number.
The latest, 23 July. So it is the statement that so far the superintendent listing department is concerned, he has submitted a report that PLA 102 capital A 1993 is not available in the CIS system, and there is no new number against PLA 102A of 1993. This
That is it, but the cost settle which is appearing in the cause list, your lordship, that is of PLA 102A of 1993. Because PLA 102 of 1993 is a different matter that has already been disposed of.
now so far PLA 102 of 1993,
That is a
it
separate,
was granted by this court.
and
but
matter
date
has
is
been
not
disposed of.
date is-
Separate cost.
It is between different parties.
Different parties. Altogether different parties. Different person who has died. That PLA
So PLA
102A
102A of 1993 was granted on 5/8/1996. It is admitted.
correct. That is
Okay.
by the Honorable Justice.
And
Raja
later
Judge.
issued on 24/12/2009. This is also admitted.
That is also admitted.
Yes, it also appears from the ledger that after issuance of the probate, multiple general applications were filed and numerous orders were also passed, which indicates the pendency of the case. And as of now, the matter is going on for a considerable period of time. So for 102A is concerned, it was granted and issued.
Granted and issued. And thereafter several applications has also
Yes,
been
yes,
filed.
yes.
But that is only with regard to 102A of 1993, not of 102.
102A, no, so far 102A is concerned, it is between some parties. 102 is with regard to different parties.
But I am concerned with 102A.
Yes. So far 102A is concerned,
वो तो भूल ही है
it is an old record and most of the case records are lying here in the court.
Lordship.
So it is difficult to ascertain whether any petition
If
was,
later new number be given by the department, your lordship, instead of 102A, later new number be given. That will serve the purpose, because the cost set, the number which has been indicated in the cause list, your lordship, that is wrong. The cost settle will not match, your lordship. Because if I apply for certified copy, or if I apply for whatever thing, I have to state then PLA 102 of 93. If I say that, that will be a different cost settle of separate proceedings.
no, so far 102A is concerned, it was granted. This is the position.
No, it was, the probate was granted, partly granted, because the order says of Justice Ajaynath Ray, as his lordship then was, partly granted probate.
102A. So far 102A is concerned, that means this
The
case,
goods of Chimanlal Bhartiya.
that means this case was registered.
It was registered as 102A. Because at that point of time, this was not the problem. There was no CIA system. So at that point of time, it was given 102A, 93A, like that.
Yes, 102A of 1993, Chimanlal Bhartiya.
Lordship.
In this case, the probate was partly granted.
Partly granted.
So this record is here, 102A of 1993.
Yes, lordship. Because previously 102A record was there. It has arrived before your lordship. Then your lordship earlier passed on direction. 102 order is different. Cost settle is different. So that has been removed from your lordship's list.
So all that is to be done is this. PLA 102A is not available in CI system. So let a new number be allotted and registered
As per the CIA system.
as per the system.
As per the system.
Yes, record and order. Learned advocate for the applicant is present. A report is submitted by the registrar original site in terms of earlier order. It is stated that the superintendent listing department, though has stated that the PLA 102 capital A 1993 is not available in the CI system, and there is no new number against PLA 102 capital A of 1993 till date. Stop. As it appears from the court records that PLA 102 capital A of 1993 was earlier filed and part probate was granted. Thus, the department, the registrar original site is requested to see that a new number is allotted with regard to PLA 102 capital A of 1993 as per the system.
Deeply obliged.
Let this matter appear on 11/8/2025 for report.
Deeply obliged.
New motion, item number 5.
Should I appear for the petition?
But I appear for the official trustee.
এটা কোনটা? এই তো এটা আগেরটাই।
নিউ মোশন হিয়ারিং করতে কি আছে? হিয়ারিং
Item 5.
এখানেই আছে। Milord, in item number 5,
Alert in this
I appear for the petitioner.
J1.
J1.
alert, pleadings has been completed, my lord. Written notes of argument, everything has been completed, my lord.
That was before the other bench.
So let
Now, Milord, that order, His Lordship Sugata Mojumdar was pleased to release the matter after hearing 30 days.
no, GA1 is for you are seeking what relief? In GA1?
Milord, relief is this is in regard to it to two trust properties lying at Shialda Boitokhana area. our relief, what we have played, my lord, for finalization of the accounts and discharge of the official trust. Because of the gross mismanagement and non-compliance of the provisions contained in the trust deed. My lord, I shall
So
place,
the pleadings, so affidavits are complete.
yes, all complete. I shall place my case one after another.
Written notes of argument.
Written notes of argument also is there. His lordship kept it for CAV, subsequently released by his lordship.
Person to.
My lord, we are suffering tremendously.
Order, my lord, passed by Justice Mujumdar, my lord. There was a direction upon the official trustee to conduct a meeting with the tenants available there. There are round about 13 tenants, my lord, and to see that whether the rent can be enhanced so that the property can be managed.
You are
properly.
representing whom?
Official trustee.
Look, those are all old chapters.
That was the observation of Justice Mujumdar, my lord.
There is no fund, old properties, dilapidated condition, no maintenance, no collection of rent for last 15 years. Look, we are suffering. We are the Shabites. This is our property. What difficulties my learned friend has to release our property? If your lordship kindly hear the entire matter, the whole thing will be revealed. Admitted special auditor was appointed. He filed a report from the High Court panel. And if your lordship goes through the report.
So this is the written notes of arguments.
Yes, both sides have filed.
Yes. What is your application? Let me see the application.
Yes, my lordship kindly go through the application. This is G1. Lord, I shall place the prayer first. That is at page 13.
Yes.
The official trustee is directed to finalize the accounts of Sudhanath Rai Trust to the satisfaction of this honorable court. B. Upon finalization of the accounts, the official trustee be directed to hand over and release the said trust in favor of the original trustees. And official directed to hand over all other copies. Now, next page, lordship, kindly come to page 14. What are the two trust properties? The schedule of the property as referred above. All that piece and storage, 3-story building, message tenement and dwelling house together with the piece and parcel of the land there too. Measuring 1 kata, 1 chitak, little more or less, situated and lying at 135 Boitokhana Road, Kolkata, Lokhon, 2007-2009. And second one below, this is a 3-story brick building, message tenement, dwelling house together with the piece and parcel of the land measuring about 4 katas, 8 shitaks, at premises number 8/1, Maharani Sharnamohi Road. Now, these are the two properties, very small properties and fully tenanted properties. Old building. Millard, I shall now place the facts of the case. But the petitioners before your lordship are the Shabites of the trust properties. Originally in 1932, that is my petition. I'm not placing the entire paragraph from my petition, but placing the gist of the case. Previously, my lord, that in 1932, a trust was created by Khirodar Sundari Rai for the purpose of well maintenance of her family, DT, as well as the family members. This was in 1932. And my lord, previously, an application was filed to release the trust estate by an application made by Sudhanath Rai. Who is Sudhanath Rai? He is the grandson of Khirodar Sundari Rai. And he created the trust with the provision that my granddaughter, after attaining the age of 30, he will take over charge. That Sudhanath Rai, he filed an application before this honorable court, and the trust was released from the and in the hands of Sudhanath Rai. Then subsequently, that Sudhanath Rai, that is the father of the petitioners, he created a new trust in 1986, creating the office.
Yes, paragraph number?
Yes, my lord. And just then, please, my lord. My lord, paragraph 2 onwards, trust was created in 1932, Khirodar Sundari Rai. And the DT is Ghanteshwar Mahadev. Then, my lord, I am not traveling your lordship to the page. Lordship, kindly come to page 3, towards the middle. The said deed also reveals that the said son, namely Nagendranath Rai, left behind a widow who was also an unsound mind and had 2 sons. Out of these 2 sons, namely Amionath Rai and Shudhanath Rai, the the present trust property, has settled all her trust estate in favor of the state Shudhanath Rai and further declared that the state trust shall be managed by the official trustee of Bengal till the principal beneficiary Shudhanath Rai attain the age of 30 years. What I have said. Then we should kindly come to paragraph number 3. It is stated that accordingly to the provisions of the provided in the said original settler, Dr. Khirodar Sundari Rai, the said Shudhanath Rai, after attaining the age of 30, preferred to file an application before this honorable court praying for release of the trust estate in his favor from the hands of the official trustee. Then, my lord, next page, the said application was allowed by an order dated 19th of December 1980, passed by His Lordship the Honorable Justice Deepak Kumar Sen, who then was, and the said trust estate was released in favor of the said Shudhanath Rai, which proves that the said Shudhanath Rai was capable of taking decisions and as well as was fully of sound mind, and like this said Shudhanath Rai managed and administered the said estate very successfully for quite some time until he himself created another trust of similar kind, which is now known as Shudhanath Rai Trust. But the present trust is Shudhanath Rai Trust. Then number paragraph 4. It is stated that the said Shudhanath Rai was a businessman and his profession demanded much more time to be dedicated towards his profession. Moreover, the general health of the Shudhanath Rai deteriorated gradually. Hence, the said Shudhanath Rai, like his grandmother, executed a trust which is the subject matter of this application and declared that the said trust will be managed by and administered by the official trustee in order to ensure the proper efficient management of the estate for the observance and the performance of the Seva Puja to maintain his family members. That Milord, we have annexed a copy of the said trust deed, but I shall not trouble your lordship to go through the entire that trust deed. Then, Milord, it is stated that from the records it transferred that during the lifetime of Shudhanath Rai, the said trust estate has started suffering due to financial crunch. As a result of such sufferings, a premises being premises number 134A, Boitokhana Road, Kolkata, 7,09,000 was sold upon due order of the Honorable Court. So one property out of this, one property was sold by an order of this Honorable Court. Now, at present, there are remaining two properties. That is what I have just shown to your lordship, that schedule at page number 14. In this behalf, it is stated that on or about January 1987, a petition was filed.
14.
I have shown to your lordship.
Schedule of property.
That is schedule of the property. That I have shown to your lordship. That I am telling. In this behalf, it is stated that on or about January 1987, a petition was filed by the present respondent before this honorable court praying for a direction upon the official trustee to sell the above mentioned premises by holding auction for the same. Said prayer was allowed by an order dated such and such, and thereafter the petition was further filed. Thereafter, a petition was also further filed on or about September 1987 by the said respondent for the confirmation of the suggestion. But at present, the said prayer was allowed, and at the premises got sold away. And currently, the trust estate consists of two properties that is contained in the schedule, details of which are mentioned in the annexure I. Then, Milord, copy of the said petition dated such and such that annexure B. Then, Milord, 6, paragraph 6. The settler Shudhanath Rai has died long back, and the trust is remaining or limping in a very slow pace, which is due to fact that no major steps are being, this is our grievance, no major steps are being taken to increase the income of the trust considering the present hard days. It shall be found, then next sub-paragraph, shall be found from the list maintained by the official trustees in respect of the tenants therein, that no major change has taken place in respect of their rents and or in respect of any eviction or induction. It is found that some listed tenants engaged subletting in their portion, taking huge money behind the back, but depositing low existing rents, and moreover, some of such tenants have been depositing their rents to the rent controller, which has now become more than rupees 30,000 since 2011. Next paragraph, madam, page. But the respondent authority taken no steps for withholding the said sums. As a result, trust facing problem. Petitioners sent several representations in this regard, but the problem has not changed so far. Present, next paragraph 7, my lord. Present beneficiaries headed by one Shambhunath Rai tried to draw the attention of the official trustee in this behalf, but such efforts failed and ultimately had to write a letter to the official trustee to release the trust estate in favor and control of the beneficiaries, like the past incident in respect of the trust dated 14/11/1932. That is the initial trust, original trust, settled by Khiroda Sundari Rai. All correspondence, my lord, I have annexed. Then, my lord, I shall not travel to reading all the paragraphs. No, দেখাচ্ছি. Next, my lordship, kindly come to page 7, paragraph number 10. The said Shudhanath Rai, the settler of the trust in question, had expired on 31st October 1993. And the official trustee had been controlling and managing the said Shudhanath Rai trust till date. Xerox copy of the death certificate annex. Next, paragraph number 11. The petitioner states that in recent past, it has become found that the original trustee and beneficiaries under the said trust are not happy with the acts and deeds of the official trustee, in as much as on many occasions it has been found that the official trustee is not acting in accordance with the provisions provided in the trust deed, as I was named Annexure A. Then we go next page. It is in this behalf, it is stated that a tenant was inducted by the official trustee in one of the properties of the trust estate without the knowledge of the beneficiaries. While in the past, every changes in the tenancy was regularly informed by the respondent trustee. In these circumstances, your petitioner has become worried and afraid about such induction, as it is both very harmful to the interest of the trustee as well as painful to the beneficiaries of the trust estate. Then we have to come to paragraph number 12. It is further observed that the property repairing of the immovable properties of the said trust is very much needed, which are being neglected by the official trustee, since repairing and maintaining of the trust properties was one main condition for handing over the trust in the hands of the official trustee. Paragraph number 13. As per the main endowment deed, it is stated that the Thakurbati of the trust property will always have to be inhabitable condition, and in terms of repairing and other conditions, but the official trustee has somehow neglected its duties, whereby wisdom of both the settler and are getting frustrated. Paragraph number 14. Further to the entire fixed deposit, this is very vital. The entire fixed deposits belonging to the trust Shudhanath Rai Trust are not properly invested by the official trustee to make more increment to the property fund, causing to the severe damage to the interest of the beneficiaries of the trust. Then I shall place paragraph number 15. It appears that the last 3-4 years, various discrepancies are showing in the statement of accounts, although same was rectified by the office after noticing the same by the beneficiaries time and again, which is very embarrassing for both the aspects. My lord, here I am stopping. Then, my lord, so our main grievance is with regard to maintenance of the property, collection of rents, and everything, and accounts.
How many tenants are there? How many?
13 tenants.
30. In both the property, total?
Total.
13, 13, 26?
No. Totality, 13 tenants.
13, yes, 13.
How much rent they are paying? for each flats?
Not flat, this is a whole building.
How many rooms are there?
কতগুলো করে আছে জিজ্ঞেস করো না মক্কেলকে কতগুলো ঘর আছে টোটাল very old and dilapidated condition building. Under these circumstances, we filed this present application. And our whole grievance is with regards to the accounts. Justice Kapoor was pleased to pass an order directing the official trustee to file a report, the accounts for 5 years before the Honorable Court. They have done that. And after going through that reports and accounts, it transpires that there are huge anomalies in the accounts.
They were not.
It was audited.
Subsequently, my lord, when the matter was transferred before Justice Sugata Mojumdar, we made a prayer to appoint an auditor from the High Court panel. And one gentleman was appointed. He has filed a report. I shall come to that. What report he has filed? What a surprising thing and very pathetic thing. How the official trustee is functioning with our properties. And in their affidavit in opposition, my lord, I just place one paragraph. The opposition, they have admitted in their affidavit in opposition just one paragraph, one sentence, my lord, not much. Why this such a gross irregularities, mismanagement, and accounts, my lord?
Technical problems, my lord, we had cured that.
My lord, Lordship may kindly come to page 5 of their affidavit in opposition. Affidavit in opposition, not misposting. There are other things we shall show.
Yes, affidavit.
How long we will suffer, my lord? How long we will suffer?
At present, what is required? You see,
What is required, my lord?
whether repair or
Repair is not possible because there is not sufficient fund. We are capable person. We want to discharge, release our property after finalization.
The building is to be protected.
No, it cannot be. But where is the money? How the building will be protected? Corporation has said about 22 lakhs is required. 23-24 lakhs is.
How much fund is there?
20 maximum 25 lakhs. If these 23 lakhs goes, then what remains? With that, they will have to be shifted. Shifting charges will have to be given. What the trust, the whole purpose of creating of the trust. একটা paragraph দেখান তো affidavit in opposition, my lord, page.
Two oppositions.
অনেকগুলো তার প্রথম দিকে যেটা করেছে 25th March 2021, my lord, just only one.
The other is on 16th day of November 22. That is supplementary affidavit.
ওটা না, affidavit in opposition on behalf of 21st.
Chiranjit Kumar Hira.
No, ওটা না, 25th of March 2021.
Yes, one opposition is here.
Yes.
No, that is in respect of account.
In respect of the accounts, they have exception to the reports.
Affidavits.
8 দেখেন 8. But they are admittedly saying that we have not sufficient staffs. Then what they will do, how they will manage?
Question is okay, you see, they are administering the trust property, but nothing will change, you see, because you see, if you don't have the funds, how will you carry out the repairs? Just as a matter of formality, you are taking it.
That is why, my lord, our submission is in such a situation. This is an application under section 29 of the Official Trustees Act. My lord, here the court has even the power to release our property. Previously, our own property was released by the court.
No, question you see, what is the present requirement? Whether have you submitted what are the present requirements? If the official trustee is unable to look into those requirements,
They are
then
admittedly saying.
no, what at present, what
Yes,
is
at
your
present.
requirements? Repairs or enhancement of the rain, what?
My lord, the tenant, they will not at all enhance. These are old tenants paying very small amount of rent. Your lordship knows the picture in throughout the Kolkata area.
They are interested to enhance the rent.
My lord, we are not interested because আমার এটা কোথায় গেল? My lord, they are saying, my lord, এই আমারটা কোথায়? My lord, I am just, if it is not available, my lord, I am just reading just one paragraph. Their affidavit. What they are saying in their affidavit. Has your lord reached Joseph? In page, lordship kindly come to page 5. I can't make it. I'm thinking they put it now. This is your affidavit. My lord, lordship kindly page 5 from the top.
Yes.
It is also pertinent to mention here that the office is also functioning with dwindling staff strength As a result of fact, at present, the office is functioning with 32 staff as against the total sanctioned post of 148. So, my lordship can see the picture. Out of 148, 32 persons are now functioning. Repeated representations are made to the Secretary, Judicial Department, Government of West Bengal for providing adequate staffs. However, till date, no new staff has been sent by the government. As a result, it becomes increasingly difficult for the official trustee of the West Bengal to run the administration and to discharging timely. If that is the position, what the repairing will do, the same thing will remain, it will remain forever. But there are provisions will not to release our.
See, if something can be done, thereafter, that is the last resort.
And in such a account, will also kindly see the accounts? What is the position of the accounts? What the
No, regarding, you see, the present position of fund immediately cannot be changed.
not changed?
Whatever you have to do with the present funds.
We can enhance the rent by.
How? If by say rent, if the tenant, what is the guarantee that tenants will increase their rents?
You see, Justice Mojumdar's order is
And-
there, that what steps you have taken.
Yes, my lord,
Pursuant to Justice Mojumdar's order.
yes, Justice Mojumdar's
Yes, you
order.
see, 26th March 2025, the official trustee was required to submit a report on extent of money needed for repairing the premises. How much you have complied this order?
Some more time, my lord.
Yes, so I'm fixing the date, you come with this instructions, submit your report in terms of 26th March 2025.
My lord, there are seven. My lord, there are seven. This is only to delay the matter.
You see, there is an order, it should be complied
Yes,
with.
yes, yes.
Yes, record an
That
order.
is true, but that does not mean, my lord, they will keep it for indefinite.
No,
period.
I am giving
And
the
we will suffer for an indefinite. period.
learned advocate for the plaintiff. You are for the plaintiff petitioner.
My lord, the plaintiff.
And learned advocate for the official trustees are present. It appears that
My lord,
on 26th March 2025, a direction was issued upon the official trustee to explore possibility of enhancement of rent. Stop. Report was directed to be filed on the returnable date on the rent payable by the existing tenants and rent to be enhanced in respect of them. Stop. It was further observed that the report shall also incorporate the area of occupation of each of the occupants. Stop. The official trustee was also directed to submit a report on extent of money needed for repairing of the premises. Stop. Although 4 months have passed, but the official trustee has not submitted any report in terms of the order dated 26 March 2025. Learned advocate appearing for the official trustee prays for time. Stop. In the interest of justice, the matter stands adjourned till 28/2025. The report shall be submitted by the official trustees without fail. The official trustees, while making the inquiry, shall, in this regard, and with regard to holding of discussion with the tenants, may serve a notice upon the learned advocate for the plaintiff.
Minute, I-
Not represented here, madam.
Whoever is represented is lawyer of the plaintiff.
Kindly, my lord, record my one submission. If no fruitful result comes out, in that event, it will be open for the petitioner.
No, let them do something. Why are you presuming? They have to do something, let them discharge their function.
And
Why are you making the task very easy?
let them proceed, let them proceed. Why they have not proceeded last 4 months? That is my submission.
They are in 86, since 86. Got transferred, madam. The new incumbent has joined, madam. We have held a meeting with them, madam. They are changing.
And you serve a notice, I have made it clear. If any meeting with the tenants or this incidental matters, notice upon the plaintiff be served.
And since 1986, the official trustee is over the properties. But what he did, one of it, and my lord, I have not today been able to place, just 1 minute. Just, my lord, able to place the auditor's report. Let
You
the-
see, you present yourself in the meeting, you see some needful is done.
And my lord, the auditor's report speaks 1200 accounts are being maintained through one account. Can it be possible? What they are doing?
That is
Anyway, you see, you hold discussions with this official trustees. I've granted that liberty.
grateful, Lordship. Grateful.
As your lordship speaks. Not returnable on matter will.
20th of August.
Yeah, you. এগুলো তুলে দেবেন।
যাকে তাহলে টাকা পাওয়ার সময় তখন বলে দিতে হবে।
আর কি বলবো? Much obliged.
Item number 6.
Your Lordship, item number 6 to 10, there is talks of settlement that is.
And I'm for the defendant number 2, the system.
The plaintiff in this matter.
We are kept entirely in the dark about
There is
this
talks of settlement going on.
Yes, Your Lordship.
But I am for the
Therefore,
We are for the intervener and applicants in item number.
who is for the plaintiff?
Lordship, I appear for the plaintiff in this matter. Lordship, I also have instructions that there is ongoing settlement going on.
So shall I refer the matter to mediator?
Well, perhaps that will be the best possible.
Lordship,
Oh,
Lordship,
no. Whatever you discuss, let it. I'm granting you time, 3 weeks, 4 weeks, how much is required? Let the talks be held in the presence of the mediator, because the possibility of the settlement will be more.
Yes.
Yes,
My lord,
record an order.
One concern of the system, my lord.
Yes.
My lord, we bow down to this.
Anyway, you
proposal.
hold discussions, okay?
Yes.
Yes, record an order.
Lordship, I also don't have any
Anyway,
instructions.
that is why I'm instead of parties, I'm making it that parties discuss and
It's a partition suit.
yes.
Lordship,
Yeah, there are, you see, many matters that refer to mediations, and the matters are being settled also.
Lordship, I keep tomorrow, Lordship, I shall come back with instructions.
No, you see, suppose if the mediation fails or settlement fails,
Yes,
I'll hear it on merits.
Lordship, I'm praying, Lordship, Lordship keeps tomorrow. I shall come back with instruction if plaintiff is
Well, on
intending
the-
to settle the same.
No,
later.
you see, just a minute. The matter is not sent to arbitrator. It's just a matter. It's a settlement proceedings before a third person.
Yes.
So the question is, it's not that I'm passing any orders on merits or I'm sending the matter to arbitrator. It's a settlement proceedings before a third party.
Lordship, may keep not
Lordship,
today.
may I-
Today, I shall come back with
Lordship, may I
instruction.
submit one thing? There are family elders of this family only. He is the one who's intervening. So they might take a back seat, Your Lordship. And this is on the words. Now they are also supposed to include and the daughter, the sister. It's basically 2 brothers, 1 sister, and their children with Akshara School of Law. So they are all getting into the settlement in consultation with another family senior.
Because see, the chance will be more.
Can I interject, my lord? I am for the system, my lord.
Lordship,
Admittedly, I am
my only humble submission is, Your Lordship, since it is being settled and it is to an advanced stage, and they are also supposed to take into confidence the sister.
So
and
you are an applicant intervener.
applicant and the son of the defendant number 2. And Your Lordship, I am also there, and we have an interim order. Lordship, I was only humbly praying if 4 weeks.
Okay, you want to come tomorrow?
Lordship.
4 weeks time is granted. In case this doesn't work out, then thereafter on the next day, Your
Oh,
Lordship. there
that
will be-
4 weeks or 5
Lordship,
weeks
I'm-
time.
Lordship, it will be completed.
My lord, may I make my submissions from it?
In case it's not taken up, then Your Lordship kindly directs the matter to
Sure,
go up
Vivek.
to the mediator.
Okay, the matter.
My lord, kindly hears me out, my lord. I'm for this sister, my lord. The problem is that, my lord, this sister, who is admittedly 1/3 shareholder of the entire corpus, my lord, which
I'm
runs
not
into
hearing the matter on merits.
my lord,
you see.
I am kept entirely in the dark about this settlement.
Lordship,
But
it will be
I have
settled,
to
Lordship.
be
Okay, then I think it would better
Kindly-
say to the mediator.
Yes, ma'am.
Yes,
Yes.
learned advocates.
Lordship,
You see, one of the parties is expressing his grievance that he is
Yes,
not
ma'am.
intimated about the settlement.
I have
Lordship,
brought into the loop,
last-
my lord. This is, my lord, this stance has been taken from July 2023 onwards. 2 years have passed. Nothing has taken place with rest.
Let them apart from the system.
My lord, but we have to be
So if you see, if sisters are not addendum,
sister, only one sister. Admittedly, I'm 1/3 shareholder. But I am kept in the dark about settlement. I have not been engaged. I have not been taken in the loop, lordship.
because there
They're
is
coming in the court expressing the desire to settle the matter. The brothers.
yes. Learned advocates for the parties are present.
Well, Kelly,
It is submitted by the learned advocates for the plaintiff, learned advocate for defendant here for defendant number 1,
defendant number 2.
and learned advocate for the applicant intervener. That talks of settlements are going on. Stop. However, learned advocate appearing for
The defendant number 2 sister.
defendant
who is
number
admittedly 1/3
defendant number 2 submits that he is kept in the dark with regard to the talks of settlement. However, as the parties have prayed for, The matter stands adjourned till 13/8/2025. It is however made clear that before talks of settlement, all parties should be intimated by notice.
Malad, one thing, Malad,
And
they
so
should
that means that-
engage the sister or take the sister into loop. Malad,
Oh, parties should be intimated by notice means
Malad is adjourning the matter for
13/13/8.
till August. Malad, in the meantime, if they prosper to continue with the talks of settlement, they should engage us also.
I've made it clear that before holding talks of settlement, notice should be served upon all the parties.
Yes, Your
That
Lordship.
I made it
Take
clear.
the sister, Malad, kindly.
You are among the party. You are not excluded.
Can you clarify, Malad?
Before your lordships only with a compromise where everyone has to participate.
Malad, but
Yes, yes. Notice should be served upon all the parties and their learned advocates.
Yes. And lordship, my interim order expires next week, next Tuesday. May that kindly be extended?
Okay, interim order
Lordship, in item number 20.
granted earlier stands extended
Similar
for a
order.
period of 5 weeks or till further orders, whichever is earlier.
Grateful.
24 is also same matter.
Same.
Okay, 24 also same order.
There is no interim order in 24.
Malad, it will be taken up along with this order.
24 is the same matter.
Same matter, but there's no
Acha,
Related matter,
item
not same.
number
different suit. 2004
আগের
suit.
যে অর্ডারটা এলাম তো let this matter appear along with CS না না যে আইটেমটা হলো তো let this item 6 হলো
10.
লাস্টের একটা অর্ডার 6 to 10 তাহলে let this matters appear along with CS 228 of 2004
Grateful. Grateful.
of 2004. হ্যাঁ ওই একই ওই তো 13 থাকছে
Adjourn motion, item number 12.
But I am appearing on behalf of the legal heirs of defendant number 2.
Heirs of the plaintiff number 3. I have served a copy of the evidence reply.
Today in the court premises, I have received the copy.
The evidence reply.
Let all relate to GA2, that is their applications, GA2 of 2024.
Yes.
And the legal heirs of plaintiff as per as per the decree of 1972, there was a settlement at page 36.
It's 36 in your application.
In my
Yes.
and that one and two shall all participate in the Shiva Puja of the defendant number 3 GT and administer the demonstration at Shivai in terms of the deed of endowment dated October 15, 1931.
No, this is clause number. Which paragraph?
Paragraph 2.
Paragraph 2. Yes, plaintiffs and the defendant number 2.
And the defendant number 1 and
Yes.
got it. Shall all participate participate in the Shiva Puja of the dependent number 3 deed and administer the Devatar estate as Shabite in terms of the deed of endowment dated October 15, 1931 of Biharilal Das. This is the manner following. A. The dependent number 1 and 2, Indra Kumar Das and Surendra Kumar Das, will act as Shabite for a period term of Pala of 1 year each, and the plaintiffs jointly will act as the Shabites for a period term of Pala of 1 year, during the term for which the plaintiffs will act as Shabites. And the legal heirs of plaintiff number 3. Other plaintiffs have died. There are no legal heirs. The plaintiff number 1, Madhavendra Kundu, who is entitled to represent his brothers. The other two brothers, the other two plaintiffs hearing and act on their behalf. If the term or Pala of Shivaitship as associate, the respective Shivite shall perform the Shiva Puja of the Shiva, effect necessary repairs, pay necessary taxes, make disbursements, and otherwise administer the Devatar estate in terms of take deed of endowment dated October 1931 and due to the continuance of the psalm or pala of one Shabite or group of Shabites as apostate, the other Shabites shall not interfere with the administration of the Devatar estate. In case of the differences of opinion, the wish of the majority of the acting Shabites, as in clause 2 within bracket A, thereof will prevail. All ladies being the associate Devatar estate during all the terms or palas as associate shall be signed jointly by Indra Kumar Das, Kolendra Das, and Madhavendra Kundu, and rent will be realized by issuing rent deeds signed. The respective device shall signing of such deeds. Collection of rent for each month shall be deposited in a scheduled bank. Names of the Shabites as mentioned in clause 2A thereof. Such banking accounts shall be operated by any of the Shabite as mentioned in clause 2. In case of death of either Kumar Das or Sholendra Kumar Das, their respective heirs along with the survivor of either of them shall be jointly entitled to perform the Shiva Puja of the said deed. Collect rent, effect necessary repairs, pay necessary taxes, make necessary disbursements, and otherwise administer the Devatar estate as apostate for periodic term or pala of 1 year, and the plaintiff shall perform the Shiva Puja of the said deed, collect rents, effect necessary repairs, pay necessary taxes and other dues, make necessary disbursement, and otherwise administer the Devatar estate for a term or pala of 1 year. In case of difference of opinion and the said Shabite, the opinion of the group. Now, this is the terms of settlement, and I am the legal heir of the plaintiff number 3. Other plaintiffs died. At page paragraph 18.
Yes. So legal heirs, you are the legal heirs of plaintiff number 3. So plaintiff number 3 also died. That is why you have come. Yes, paragraph 18.
No, my lord, 8.
Yes.
Madhavendra Kundu was childless and died. Wife also died, Radha Kundu. And the plaintiff number 2, Ashok Kumar Kundu, unmarried, died also. And said Rabindranath Kundu, plaintiff number 3, the plaintiff's hearing, the applicant's hearing. The wife and son. So, my lord, as per said settlement, I am entitled to act as Shabites. Now I'll come to my preamble.
Now, what function you are discharging now?
I'm just celebrating puja and pala, whatever may be, from my own account. Because initially there was a receiver, thereafter receiver discharged, another receiver appointed, no functions, And my learned friend also, I think also, in their opposition also said so. Now the completely deadlock position in the states because of non-management.
Let him complete.
My lord, my prayer is also I am entitled to act as Shabite on behalf of the plaintiff side, and their opposition, they have also admitted my position, and they have also admitted that yes, jointly their branch or our branch will act as jointly by each year wife perform Pala and other Shabite sheets, that is collection of rent and removing of trespassers. There are a number of trespassers, my lord knows, the whole estate. My understanding, and to directions upon the
Page.
yes, my lord. The petitioner may be allowed to use page 16.
Okay, paragraph 8 you have stated.
Yes. And the order may be passed so that patent applicants may be act as Shabite ships on behalf of the plaintiffs as per the settlement which was agreed in 1972
Along with other Shabites.
along with others. I have no objection.
Yes.
My lord, I am appearing on behalf of the legaliers of the Shabite, who is the defendant number 2. As per
Legaliers
the
of?
terms of settlement, as
Of?
per the terms of Sholendra
Defendant number
Kumar Das.
2.
Defendant number 2.
Sholendra Kumar Das.
My grandfather. Now the situation is that on the basis of the terms of settlement, that is 2D, I am also the Shabite in respect of the said 2 properties. Actually, there are 2 properties. One is the 21 Kanaidhar Lane and another is 58B Potuatola Lane. So these 2 properties are fully tenanted properties, and so many trespassers are theirs. I am agree with the with my learned friend also, and only my oppositions in respect of their prayer in applications G2, which is their applications.
What is your affidavit?
Oppositions is, my lord, in respect of their GA2, they have stated in the prayer portion, that is 24B. At page 10, at page 16 of their applications.
Yes.
The petitioners, in discharge of their duties as trustees in terms of prayer A, be empowered to take the following amongst others. So my objection in regard to that, the petitioners are not only the Shabites in respect of 2 properties, we are also the Shabites because we are also the legal heirs of defendant number 2. So discharging the duties on their part, I am also entitled to, or the legal heirs there, because there are 3 legal heirs of Sholendra Kumar Das who are surviving right now. So these 3 legal heirs are also entitled to discharge or performing their duties as per the whatever they have written.
Question is, petitions in discharge of the duties be empowered to take. So to collect rent. At present, rent is being collected from whom? Who is collecting the rent at present?
Because
that is actually, my lord, the position is that initially there was the receiver, thereafter receiver discharged, 4th receiver appointed, no functioning, dispersers are.
Who is operating the funds of the trust?
That is one of the questions, my lord.
Who is operating the funds? Suppose
because
rent is received and deposited in the fund of the trust. Okay, trust account.
in the name of the deity.
Yes, in the name of the deity.
But bank operation is almost now closing step. No operation is being running in the bank account because your receivers who appointed by this court,
They failed to, yes, they failed to discharge his duties.
He's not discharging anything. Either not collecting rents, not depositing rents. Someone voluntarily some donations for the pujas and someone not paying any rents. So the totally deadlock position in the place. And
Now the present you see, you want yourself to act as a Shabites. Okay. So your learned friend is objecting is this, why you yourself will act as?
No, I'm also with him. As a joint. As per the settlement, terms of settlement, I shall act as a joint trustee, pala wise, year wise.
Why not the terms of settlement?
I have no
Terms of settlement to be what
Yes, during the term or pala.
Yes, in case of death of either Indra Kumar Das or Shailendra Kumar Das, the legal heirs of Indra Kumar Das did not turn up before the honorable court.
So during the term of
Shailendra Kumar Das.
no, page 37.
This is 38, my lord.
38.
Terms of settlement.
38. Either Indra Kumar Das or Shailendra Kumar Das. Shailendra Kumar Das you are representing?
Yes, my grandfather.
Yes.
So there are three legal heirs.
Their respective heirs along with the survivor of
Yes.
either of them shall be jointly entitled to perform the.
Yes.
So that is clear.
That is clear.
Collect rents, effect necessary repairs, pay necessary taxes, make necessary. So it is very clear.
Very clear as per the, because we are also the Shabite in terms of this settlement also. So here my learned friend in their applications of GA2, what is they have written there, that I only object. In respect of only they are empowered to collect rates and everything.
Page 36, that is also clear. The defendant number 1 and 2, Indra Kumar Das and Shailendra Kumar Das will act as Shabites for a period term.
Page 36.
Page 36.
No, Indra Kumar Das and Shailendra Kumar Das are no more in the picture.
Yes.
So
But this is
your learned friend is representing the heirs of Shailendra Kumar Das.
I am representing the plaintiffs.
No, me.
Heirs of Shailendra Kumar Das.
Yes.
And you are representing the heirs of plaintiff number
3.
Plaintiff number 3. Who was plaintiff number 3? Rabindranath.
Kundu.
Because this Indra Kumar Das, nobody came on behalf. On what grounds you want yourself to be appointed?
Because, my lord, I have stated in paragraph 8. Paragraph 8, my lord. Paragraph 8, page 8 of my GA.
Yes, paragraph 8. Yes.
Thus said, Madhavendra Kundu, that is plaintiff number 1, was childless and died intestate on 9/7/2015. And his wife Radha Kundu died 26/4/2018. I have annexed all death certificates.
Yes.
And the said Ashok Kumar Kundu was unmarried, died intestate on 5/3/2006. And said Rabindranath Kundu, that my father and husband, Rabindranath Kundu, plaintiff number 3, died intestate on 28/2023, leaving behind his wife Parvati Kundu.
No, from paragraph 8, okay, the right of Shabiiteship evolves upon the heirs of Rabindranath Kundu. So, from the scheme, from the settlement, why do you get that? From the, your right should come from the scheme, that is from the trust, settlement. So, which clause of the settlement deed you rely upon, so that the heirs of this Rabindranath Kundu gets the Shabite rights?
I am reiterating, madam, page 36.
Page 36. Yes.
The terms of settlement.
Yes, yes.
Which is entirely
Okay, that 1, 2, and 3.
Yes, yes.
Okay, okay. 1, 2, and 3 were declared Shabites. And 1, 2, and 3 are declared as Shabites, and the heirs of 3. You are the heirs of 3.
Heirs of 3.
So why do you get that heirs of 3? That Shabite right?
First comes page 2. the plaintiffs and the defendants number 1 and 2
Yes.
shall all participate in the Sheba Puja of the defendant number 3, that is DT. Paragraph 2. And administer the Devottor estate as Shabite in terms of the deed of endowment dated October 15, 1931. That is the settlement of Biharilal Das in the manner following. Now, subpara A, the different number 1 and 2, Kumar Das and Shodendra Kumar Das will act as Shabites for a periodic term of pala of 1 year each. Man. They are entitled for 1 year, and I am entitled for 1 year. And the plaintiffs jointly will act as Shabites, and the plaintiffs and the legal heirs of the plaintiffs jointly will act as Shabites for a periodic term or pala of 1 year. And I am also entitled for 1 year. They are also entitled for 1 year. They are jointly entitled for 1 year. I am being the heirs of the plaintiff is entitled for 1 year. That is the settlement, my lord. On that basis, I pray for Shabites. For which the plaintiff will act as Shabite, the plaintiff number 1, Madhavan entitled Madhavan Pundu, my predecessor, will be entitled to represent his brothers, the other 2 plaintiffs, hearing and act on their behalf.
Yes, that right is already conferred in terms of the settlement, that original plaintiff. So, from as these years, you are now claiming the Shabite rights. Yes, so far defendants heirs are concerned, they are also exercising the rights of Shabites,
Yes.
performing the duties. Now, only thing is the fund is also not being operated.
That is the main problem.
Only I have the objections in regard to their prayer portions, that is prayer B, that only they are not entitled to get the or
How many
empowered-
properties are there? 2 properties.
Properties are there.
2 properties are occupied by tenants.
Occupied by the tenants and also the trespassers and the illegal occupiers. Various things are there.
So rents are not being collected.
And another thing is that, my lord, I have only objections in regard to their para number 8. What they have stated here, that the Rabindranath Kundu died and such, Tapush Kundu as his heirs and would develop upon legal heirs of applicant therein. So they are not only the Shabites, we are also entitled to Shabites as per the terms of settlement of the this one.
That right evolved on us only on the restricted to the plaintiffs, not the Shabite rights.
Para 2, my lord, in the
No,
terms of
difficult,
settlement,
my lord.
page number 36. The plaintiffs and defendant number 1 and 2 shall all participate in the Sheba Puja of the defendant number 3 deity and administer the Devattar estate as Shebites in terms of the deed of endowment dated 15th of October 1931. So we are the legal heirs of the defendant number 2, who is my grandfather. And 2A, the defendant number 1 and 2, Indra Kumar Das and Shodendra Kumar Das will act as the Shivites for a periodic time of 1 year. So we are the Shivites.
Yes, that's all. Yes, record and order. Learned advocate for the applicant and learned advocate for. You are not in the record. Learned advocate representing the legal heirs of defendant number 2.
Sholendra Kumar Das.
Yes, Sholendra Kumar Das are present. Are learned advocates on GA2 of 2024. The hearing is concluded. Let this matter appear for orders on 6/8/2025. 6/8. For orders.
My lord, one thing is I have also served upon the defendant number 1, that is Indra Kumar Das.
Anyway, affidavit of service is there.
Respect of the other property, that is 58 Kotuadara Lane, it's totally occupied by the
This application suit is with regard to both the properties.
Both the properties.
Rents and occupants with regard to both the properties.
Item number 13.
My lord, item number 13, my lord, I beg to appear, my lord, for the plaintiff virtually. My lord, I apologize at the first onset, my lord, I'm appearing online. My lord, before my learned friend commences, may I just indicate two things?
But I am appearing for the plaintiff petition. It is my application for amendment of my mean profit application only to that extent that the ascertainment of the mean profit prayer was not there. Though the application has been filed, but my GA 18 is my application for mean profit. And in GA 19, my lord, I have actually made an application only to insert that prayer, that ascertainment of the mean profit, that prayer is missing, so that may be included.
My lord, I want to file an affidavit to that. I'll indicate, my lord. I'll just indicate. I don't want to interject, my lord, with. Very well. My learned friend can continue. I'll say. Speak.
I am for the plaintiff.
Yes.
My lord, earlier, my lord has passed an order in that execution application on 15th of July and asked the deputy sheriff to actually to execute the writ of possession by reviewing the judgment letter. And the bailiff has executed the writ of possession and filed a report. And this is the order which was passed by your lordship on 17 July, recording that the execution has been complete and the judgment debtor has given the vacant and peaceful possession of that property to the plaintiff. My lord, this is my only application seeking for amendment of my portion of the prayer where the ascertainment of the mean profit is required to be inserted. My lord, they have asked for affidavit in opposition. Number of times they have failed to file their affidavit in opposition. Last occasion.
Which application? GA 19.
GA 19 is the amendment.
Occasion, my lord, has passed an order. Let them actually file their affidavit in opposition by certain time. That time has also expired, I think, on 15th July. 15th or 16th July, they were about to file their affidavit in opposition. And they were also asked to actually put in cost of 200 gems. That they have also failed. And now they are coming actually.
That cost is also not paid.
No, I'll indicate, my lord. I'll indicate every. May I just take 2 minutes, my lord?
Kindly see my lord's last order, which my lord has passed.
No, this is the order is dated 7th of July 2025.
There is a direction to pay the cost.
Yes, I am carrying that, my lord. If your lordship looks at the order dated 7th of July 2025, the order, my lord, did not perhaps clarify who am I to pay this to. So today my advocate on record is there present in court. He's carrying a check. If your lordship specifies who we pay this to, we'll pay this immediately. But that is not even the bone of contention, lord. That is, I'll pay that money by today itself.
That is definitely to the decree holder.
No, I'll indicate what the facts are. I am the plaintiff in the suit. The suit was for delivery up and cancellation of an instrument. The defendant who's appearing today, he was one of the counter claimants.
Yes.
Now, my suit gets dismissed by the trial court. His counter claim for eviction gets allowed.
Yes.
Now, that was in the nature of a preliminary decree. With respect to the main profit, there was no finding that was arrived at. Now, with respect to the execution of the preliminary decree, they have put it into execution. Now, they come up with a second application for the purpose of, my lord, payment of mean profit. Their original application for payment of mean profit, which is GA 18.
An opportunity to file opposition
Yes.
was. So
Yes.
that you have not yet filed.
No, there's a reason for that, which is why I wanted to, my lord, come and make that submission before my. He'll not interrupt. I did not interrupt him. Please don't interrupt, sir. The difficulty was, my lord, there's a change of advocate that has taken place day before yesterday. The original panel of lawyers who are handling this for the plaintiff, that is my erstwhile lawyers, my lord, they have given the brief. In fact, my advocate on record, Mr. Kabir, is present in court. He has not been able to take all the documents. In fact, GA 18 and GA 19 are the only two GAs that are with me. When I was sitting with him on a day before yesterday, I didn't even have a copy of the plaint in front of me. So they are in the process of collecting it from the erstwhile advocates. I understand that even with the erstwhile advocates, there was a delay. So I am willing to pay the cost. But I was only praying for another 7 days time to put in, just for the interest of justice. Lord, she will allow me to put in that affidavit in opposition.
You are ready with the costs.
I am ready, my lord. Only the name to the payee is not there. But ideally, my lord, I will insist if your lordship, my lord, recalls that order, and there's also a reason. I'm willing to pay without prejudice to that. I make this submission. My lord, there's a change of advocate. My lord, today the new panel has come in. Lordship will not allow the litigant to suffer for the faults of the advocate. I don't want to make any personal allegations against anyone. But Lordship will kindly, my lord, show some mercy to us and not make us pay that cost today. Lordship has under 215 of the Constitution, Lordship has the power to recall its orders. Lordship will give us one last chance. 7 days we'll put in the affidavit in opposition.
My lord, in these applications, GA 19 is a very simpliciter prayer.
Would be let affidavits go in, then we'll decide whether it's simple or complicated.
That from the date of in wrongful possession till delivery of vacant possession, ₹100 per day should be given. And I have made an ascertainment of around 12 lakhs of rupees is remaining due, which is required to be paid till the judgment debtor hands over vacant possession to the decree holder. My lord, thereafter, my lord, I have only asked for slight amendment to that.
You have waited for so long, just wait for 7 more days. Anyway, it will be taken up.
They have now gone for change of advocate, and this is the third time. That's why the matter is appearing as last chance. My lord, also kindly see the.
He's absolutely right. There have been latches on the part of the erstwhile advocate, which is why it's last chance. Let not the litigant suffer because of that.
Actually, they have given that last chance to file their affidavit in opposition.
That's right.
That
Yes,
is also
record an order. Learned advocate for the parties are present. Today, the matter is appearing as a last chance to file the affidavit in opposition. Learned advocate for the opposite party submits that as it is a change brief, necessary papers could not be collected to file the affidavit in opposition, and prays for one more week.
Yes.
Be collected to prepare the affidavit in opposition, and prays that one more week be granted to file the same. Learned advocate appearing for the petitioner objects to the prayer. Stop. In the interest of justice, time to file affidavit in opposition stands extended till 31/7/2025. Reply, if any, by 5th August.
1 week will be enough, my lord. If they file within time.
No, 31st July.
31st July.
By affidavit in opposition.
And 7th August. 7 days time
Okay.
be given.
Reply by
At least 1 week.
7/8/2025. Let this matter appear on.
And my lord, the cost also, which is there in the
11/8/2025.
The cost may be.
Well, the cost, my lord, can be reconsidered, my lord. That was directed to be paid on 7th of.
No question.
Very well. I'll pay it today.
Cost be paid in course of the day.
No, lordship will have to specify, my lord, who we pay this to. I have a blank check. Not blank check. I have a.
Cost be paid in course of the day, either to the decree holder or to the learned advocate on record for the decree holder.
Yes, ma'am. Please, your lordship.
We'll pay it. I'm extremely grateful to your lordship.
Grateful, Your Honor. Item number 14 and 15.
14 and 15, my lord, I appear for the petitioner in both applications. I am the caveator in the testamentary suit. My lord, I've had to take out these two applications, especially, my lord,
I'm
today.
opposing, Your Lordship, this application. There
But
are
may
two-
I file my affidavit in reply to GA4?
One is, Your Lordship, GA number 3, that is for Your Lordship appointment of administrative pendentalite. and GA4, your lordship, they have filed in the nature of 340. So, your lordship,
GA4 is a contested.
GA4, my lord, is
your lordship,
being contested.
Or
May
your
I file
lordship,
my
the
affidavit in
340
reply?
application filed by them.
Anyway, it has to be heard out.
Yes, my
Yes,
lord. My lord, what I was only teaching,
May
my
I
lord.
file your lordship affidavit in
GA4, my lord, is a perjury application. That, my lord, we can make submissions. We're filing our pleadings today. GA3 has been ready for hearing, my lord, for a while now. And I'll indicate, my lord, there's some urgency in the matter. This is, my lord,
GA3 is whose application?
my application for
You are
appointment of
ready, you have filed
administrator.
your affidavit.
Yes, my lord, it's been a long while back, my lord.
Reply is
Pleadings
also
are
filed.
it's already
Everything is
filed.
completed.
My lord, my only prayer is, my lord, may I start my arguments today? It's a short matter. I'm seeking an appointment of an administrator pendentility on the ground, my lord, that the executors today are acting in derogation of the estate of the
Your lordship,
testator.
complete the submission. I'll complete it next day, your lordship. Let him complete.
I'll take 10
standing on
10
the
minutes, my lord. I won't take much time.
Yes.
ठीक है, बोलो.
GA3, my lord, will kindly have my petition. I'll just indicate before I take, my lord, through the papers, my case in short. My lord, the testator, my lord, has GA3. GA3 to the- My lord, GA3, my lord, will have my prayers first. My humble submission before my lord today, in the facts and circumstances of the present case, the order for appointment of an administrator pendentility, my lord, in this case should be a matter of course. I'll indicate why. My lord, we kindly take the master summons, my lord. My lord, prayer A is my prayer for appointment of myself to be the administrative pendentility. My lord will kindly consider prayer B first. Prayer A is a higher test to my lord meet. Prayer B, my lord, I would be pressing for of the master summons.
Prayer B.
Prayer B. My lord will appoint any person that my lord deems fit and proper, any independent person, to be the administrative pendentility over the estate of the testator. Because I'll indicate from my application that the estate of the testator has been substantially dissipated and siphoned off by the plaintiffs before my lord, who are the respondents in this application. My lord, the testator in the present testamentary proceeding is my father, Mr. Bhagirath Murarkar. My lord, he has allegedly left behind a will of 20th October 2001. My father died on 5th September 2002. Less than a year from execution of this will. I am contesting the testamentary proceeding. They have also, under my lord, circumstances which are suspicious, my lord, obtained the signature of my father on this alleged will, which is under contest. Now,
No,
admittedly, I'm the son of the testator.
No, question is,
Man.
executed is appointed by your, allegedly appointed by your father.
Yes.
Okay.
Yes.
That will you are contesting.
Yes, my lord.
So this application is for?
This application is for appointment of an administrator pendentility. Normally, a court will not replace an executor appointed by the testator. This is a settled proposition of law. But there are exceptions to this, and I will show that when a bona fide case has been made out by a party to the testamentary proceeding, then it is a matter of course for an administrative pendentility to be appointed. And this is the settled proposition of law as laid down by this honorable court and which has been followed also in other courts. Well, I'll be relying upon two decisions to this effect. My lord, in short, may I just give my lord a background of the case before I take my lord through the papers? Not many papers. My father died less than a year after execution of this alleged will. Thereafter, my lord, according to the stand taken by the plaintiffs' respondents in their affidavit in opposition to my application, within 15 days of my father dying, a letter was written by the sole beneficiary under the will, that is my mother, who has also now passed away, transferring the entirety of my father's shareholding and mutual fund holdings in his demat account to her account within 15 days. I will show that. That's on record. That's an admitted fact. Within 15 days. And what does my mother, who is again today deceased, I discovered all of these things after her death. My mother thereafter allegedly transfers those shares to a trust of which the beneficiary is surprisingly the plaintiffs before your lordship. The trust is controlled substantially by the plaintiffs. This is just a ploy that has been set up by the plaintiffs in order to siphon off the estate of the testator, which admittedly existed as on the date of his death. And why do I say this? The plaintiffs before my lord, who were appointed allegedly as executors under the will,
Beneficiary in the will.
beneficiary in the will was my mother. Shashi Murarka, who was the widow of the testator, was the sole
The
beneficiary. Sole beneficiary. She admittedly died after the testator. I, as a son of both my mother and my father, I have an interest in at least 1/3 share because 3 children are there. I have a share in at least 1/3 of the estate of both my parents.
Regarding your
After the death of my
your mother did not leave any will.
No. So I'm entitled to 1/3. I have interest in this matter. I have a substantial right in the estate of both my parents. Now, what is surprising to note is, according to the plaintiffs, my mother has written to the shareholding company.
So what is the relationship with the plaintiff and the testator?
Plaintiffs are, my lord, plaintiffs are appointed as executors under
Yes,
the
between
will.
executor and the testator,
Yes.
any relationship?
My lord, I don't believe there's a case. Huh? Daughter-in-law, they're daughter-in-law, not daughter. They're not daughters of the will. My lord, will kindly have the may I show the will first? Huh? Nisha is daughter, not Neeraj. Neeraj or Rita? Okay. Daughter. Only one of the executors is the daughter of the testator, and the other, the first plaintiff, my lord, is only a wife of one of the relatives, my lord, a relative of the testator. Relative of the testator. My lord, I am entitled to 1/3 share in the estate of the testator. That is an admitted position, but I am challenging the will in total. My case today is, my lord, within 15 days of the death. May I just show the will first and foremost, my lord, so that my lord's conscience is clear as to what the or rather what the beneficiary under the will named is. My lord, the will starts at page 17. Page 17, my lord, is the alleged will.
Yes.
It's an unregistered will. My lord, will find the signatures of the testator at the bottom left, alleged signatures, my lord. Thereafter, my lord, will kindly take page 18, that shows, my lord, the beneficiary. Third paragraph from the top. I give, devise, and bequeath all other my properties, assets, rights, and claims whatsoever, wheresoever situated in my possession, reversion, expectancy, or remainder, including the bank balances and shares, to my wife Shashi Murarka, absolutely and forever. Prior to that, my lord, some dispositions as to tenancy are made. Apart from that, universal legatee is the widow of the testator. This is admittedly my mother. The next paragraph states that in the event Shashi Murarka predeceases me, the testator also lays down the guidelines for disposition. But this has never arisen. Even here under, my lord, I am recognized, just for my lord's satisfaction, page 19, my lord, will kindly take. Page 19, my lord, shares are also left to my son. Clause F, my lord, will find. My son is also recognized. Huh? Correct. And D and F are the shares to which, even in case my wife, or rather the wife of the testator had predeceased him, I would have gotten a share. Now leave that aside, my lord. My lord, here, on the date of filing of the probate application, my lord, an affidavit of assets was filed by the plaintiffs, who are the named executors. The affidavit of assets, my lord, will find at page 52 of my application. 52. My lord, will see this is an affidavit of assets. Specifically, my lord, will kindly take page 56 of the affidavit of assets. Page 56, my lord, will see substantial, my lord, property in public companies. My lord has 56.
Yes.
Here, my lord, will find investments made by the testator during his lifetime, and this is affirmed as on date of filing of the probate application. My lord, substantial sums are there. These forms, my lord, that's annexure X1 and X2, are also annexed at page 62 and 69. Correct. 62 onwards is the chart that sets out all the shareholdings. Entirety, my lord. My lord, will find that continuously till 72, and even thereafter, my lord, till 78. Till 78, my lord, will find several companies in which my father had held as on the date of his death substantial shareholding. Now an executor comes to this honorable court, files an affidavit of assets, claims herself to be the executor of the estate, is enjoined with a duty to ensure this estate is preserved. This is as per section 211, your lordship already knows, 211 enjoins the executor to preserve the estate. Now what does the executor do thereafter? My lord, we'll see the date of affirmation of this affidavit, page 61. Page 61, just the date for formality sake, 24th August 2007. This is affirmed. 61.
Yes.
My lord, will kindly note the date, 24th August 2007. My father had died, my lord, again in 2002, 5th September 2002. 5 years thereafter, this probate application comes in. But even so, this is admitted. Now, what happens is shocking. My lord, will kindly see page 95 now. Page 95, I write to the depository holder, which was in charge of the demat account that was held by my father.
Yes.
My lord, will kindly see that depository holder writes to me, Praveen Muraka is my client, 95, your letter dated so and so, so and so. The statement of my father's demat account is communicated to me. My lord, will kindly come to page 96. This is the only shareholding of my father that is left. Only shareholding left are these few shares in DSQ Software Limited. The entirety of the shareholding, which was shown to be in the name of my father, as on date of filing of the affidavit of assets by the plaintiffs themselves, are gone. Do they dispute this? Now, your lordship might inquire as to what stand the plaintiffs have now taken in their affidavit in opposition. They could have disputed it. They could have said, no, the shareholding status that has been shown by my client at page 95 and 96 is false. On the contrary, they admit to dissipation. Well, we kindly take page 8. Page 8 of the affidavit in opposition. I'm sorry, of the affidavit in opposition. Page 8 of the affidavit in opposition, Muller will kindly take Q. Muller will take subpara Q. Muller will see the stand taken by the plaintiffs after having affirmed the affidavit of assets.
Oh, affidavit in opposition by Nisha Singhania.
Yes, my lord. Yes, my lord. Of May 2024.
Of
May 2024.
22nd May 2024.
Yes, my lord.
That is page 8 is P and Q.
Yes, my lord. Q. I am drawing my lord's attention
Q,
to
yes.
Q. May I just place this? Upon the death of Bhagirath Murarka, his wife, Srimati Shashi Murarka, issued a letter dated 10th September 2002. Kindly notes the date and kindly notes the suspicious circumstances in which this has been done, alleged to have been done. 2007, my mother has passed away. Malavli, kindly take this in mind. 2024, this comes. 10th September 2002, to Vedika Securities is that depository holder at page 95, which I had shown, informing the death of her husband and requesting all shares lying in the demat account of Bhagirath Murarka be transferred in her favor. Next page. Pursuant thereto, on or about 17th September and 22nd November 2002, Vedika Securities Private Limited has duly transferred so-and-so. Within 5 days of the death of her husband, the plaintiffs would have, my lord, believe that the widow of the testator writes to the depository holder for transfer of the entire shareholding. Now, this could have still been accepted by me, if not for their own affidavit of assets. My lord, will recall the date on which it was affirmed, 24th August 2007. They state on oath that my father, Bhagirath Murarka, had in his name all the accounts that are there from page 69 onwards of my application. That's a part of his affidavit of assets filed by the plaintiffs.
Now, and it is found that
my lord,
this, okay, at present only this much is left.
Yes, my lord. At present, only 3,000 shares in DSP. Exactly what I had shown. Page 96, my lord, we compare this to page 96 of my application is exactly that. This did not. Page 15 also, my lord, will find a similar averment towards the middle of the affidavit in opposition, my lord, will kindly take. Page 15, towards the bottom, my lord. Towards the bottom, my lord, last 5 lines, I say that the shares had been transferred in the name of Shashi Murarka on the basis of nomination during her lifetime, and the petitioner was well aware of that prior to 2008. My lord will now compare these statements which have been made on oath in the affidavit in opposition to again the affidavit of assets that's a part of my application. My lord will kindly have a look again at the affidavit of opposition just to show the falsity in the stand. My lord, page 52 of my application again, my lord will kindly have once. 52. This is an affidavit again affirmed by both the plaintiffs, page 52 of my application.
Yes.
My lord will kindly see paragraph 1. The testator has died on 5th September 2002. This is also an admitted fact. The next page. Prior to his death, testator had made a will, 20th October 2001. 3. We have truly set forth, as far as we are aware of, and have been able to ascertain in Annexure A hereunder, appearing all the properties and credits which the testator above named died, possessed of, and entitled to at the time of his death. This is his averment on oath. And thereafter, in the affidavit in opposition filed in 2024 after the death of my mother, he informs me, no, we were wrong. Everything has already been siphoned off, has already been disposed of. Now, my lord will kindly also note this affidavit of assets is affirmed on 24th August 2007. My mother, my lord will find that from page 61. Page 61 of my application. 61 of my application. 24th August 2007. This date is also relevant. My lord will find that my mother, Shashi Murarka,
No, page 60.
61, the date of affirmation of my application, 61 of my application.
24th August 2007.
Yes, this is of relevance. I'll tell my lord why. For 24th August 2007, this affidavit of assets are affirmed. My mother has admittedly passed away on 14th August 2007, 10 days before this affidavit is affirmed. So today, laying blame on my mother, saying that 5 days after the death of the testator, my mother had written to the depository asking for transfer. This statement also comes 10 days after the death of my mother, who had died on 14th August 2007. My lord, just to satisfy my lord's conscience, the document in that regard is at page 45 of the affidavit in opposition. My lord, will kindly have the affidavit in opposition once. My lord, my page numbers are a little struck off. I hope, my lord, page 45 is the correct page.
Page 45.
Page 45. Eh? It's the death certificate. Death certificate. 45. 45, my lord, will find the death certificate. 45. 46. My lord will give me one. 46. My lord, 46. My lord will kindly have one. I'm sorry. Huh? 46. 46. 46. My lord will see the date of death. The registration certificate is issued towards the bottom, 14th August 2007.
No, page 46 of your application.
46 of the affidavit in opposition. I'm sorry, but affidavit in opposition. Date of death is 11th May 2007.
Yes.
46, my lord, has it's a death certificate of Shashi Murarka, my lord. Has that? My lord, date of death, my lord, will kindly take 11th May 2007.
Yes.
14th August 2007 is the date of death, or rather, date of registration of the death.
This certificate.
Yes, issuance of the certificate, registration of the death.
Yes.
After all of this, they come forward and file the affidavit of assets. The entire proceeding has been initiated for probate of the will of my father, who had passed away in 2002. In 2007, after the death of the widow who was the beneficiary, my lord will kindly appreciate the ploy that is being tried to be.
Probate proceedings filed in the year 2007.
After death of my mother. The only person who could have come before this honorable court and actually espouse the truth has passed away. Thereafter, the plaintiffs take steps because they know that if my mother was alive, well, the entire ploy would have fallen through. My lord, this is the circumstance in which I seek today, my lord, in view of the prima facie evidence that I have shown of some wrongdoing, of some dissipation of the assets as compared to their own affidavit of assets, I am seeking an order for appointment of administrator pendentility. On this ground, my lord, may I cite only two judgments of our honorable court. My lord, may I first cite, my lord, a division bench judgment. My lord, it's an unreported decision. May I just hand up a copy? Amount of mark or act. My lord, will kindly just, it's a general proposition of law. My lord has seen it numerous times. My lord, will kindly have page 4. Here, my lord, the case related to a first appeal, wherein an order of injunction by the probate court was refused. The Honorable High Court set aside that order and granted an order of injunction. And while doing so, my lord, certain observations have been made as to the role of the probate court. Page 4, my lord, will kindly take the bottom paragraph at page 4. The probate court enjoins power to protect the estate and to see that it is not diminished or dissipated in the course of such proceedings. And we do not find any obstacle on the part of the probate court in exercising the equitable jurisdiction to protect the properties to be interfered with until the final decision is taken thereupon. Next paragraph. It is sought, my lord, will kindly turn over the page. It is sought to be contended before us that if a question as to the effect of the Hebanama, here, my lord, there was a will that was, or rather a gift deed that was executed. And on that ground, my lord, the probate court had refused the ad interim order of injunction. As to the effect of the Hebanama executed before the testator during his lifetime is raised, the court should not shirk its eyes to the aforesaid fact and proceed to pass an order of temporary injunction in respect of the properties which the testator did not possess and or own at the time of execution of the will. In this case, my lord, the affidavit of assets clearly admits on my learned senior friend's part, on the plaintiff's part, that these properties were held. It is only subsequently when we discover that actually nothing is there, at that point, they take this stand. Oh, sorry, I forgot to mention, we had already, the entire property was disposed of prior. My lord, will kindly now take the last para at that page. My lord, not necessary. Here, my lord, only the last portion, my lord, will take. Here, an ad interim order was passed, page 7. In such view of the matter, middle paragraph, my lord, page 7. An interim order of injunction was passed. In view of such matter, the application for temporary injunction is disposed of, restraining the respondents from alienating so and so. So here, the order of the trial court, my lord, refusing to grant injunction was set aside and an injunction was granted by the Honorable High Court. Now, my lord, the decision of our court, wherein, my lord, the test for appointment of administrator pendentility has been laid out, my lord, in the judgment reported at 2006 SCC Online Cal 280. 39 seconds. Well, I will kindly take para 32. Para 32. Well, it is empowered under section 247 of the Indian Succession Act to appoint an administrator pendentility. 32, Muller will take. Appointment of administrator is made when the preservation and protection of the property is required. According to them, the nature of the property in this estate are such that it can easily be protected and preserved, and indeed they have been preserved. The Birlas have given inflated valuation of the estate, and there is no support of such valuation. The nature of the estate are shares in various MP Birla group of companies, shares in other companies, so and so, 1/5 undivided share of goods, pearls, books, plate, antiques, investment in mutual funds, similar to our case, and government companies. As far as the balance sheet of Priyamvada Devi Birla on 31st March 2004 is rupees 1.21 crores, approximately as stated in the affidavit of assets by Lodha. Since the main assets of the estate is controlling block of shares in the MP Birla group of companies and the power and control is the main asset, the control must be preserved or dissipation in controlling block of the shares of MP Birla group of company by transferring any shares belonging to the estate has already been restrained by an ad interim order against the Lodhas. Well, I will kindly take page para 39. Malad, section 247 is also set out on that page. Malad will take para 39 and page 17 of the downloaded copy. Malad, section 247 is also quoted at the top, the first paragraph, unnumbered paragraph on that page, my lord, section 247 of the Indian Succession Act is set out. My lord, the only statutory test that is there is necessity. There must be a necessity for appointing of an administrator pendentility. Para 39. In spite of the provisions vesting as under section 211 of the said act, the effect of vesting is that possession, control, and management of the estate vested with the executor. However, in my view, such right is not an absolute one, and the same is subject to the provisions of section 213 and 214 of the Act. In spite of the above right of the executor on the death of the testator stroke executrix, the provision of appointment of APL under section 247 has been provided for. Therefore, it is clear that executor cannot have, by virtue of section 211, an absolute right to manage and control the estate left by the testator testatrix. It appears that the principle for appointment of APL in a testamentary action was laid down for the first time in Biliu versus Biliu, 1865 so and so, probate division of the English Code, as there was no defined principle for appointment of the relevant statute, viz. Court of Probate Act 1857, though the power was conferred upon the court. However, in this case, as a matter of principle, well, thereafter that English case is discussed. Well, I'll just hurriedly read through para 46 thereafter. Para 46. Para 46, my lord, is an old decision of our court. In the case of Sudhirendra Nath Mitter versus Orurendra Nath Mitter, AIR 1952 Calcutta 418, while discussing all the case decided in the past on the question of appointment of administrator pendentility, the learned single judge of this court held that in all cases where necessity is made out, appointment be made. The word necessity is also explained in this judgment as an illustration in paragraph 14 of the said judgment. It was spoken therein. The necessity arises when there are assets to be collected. There is no representative to collect them. There is a, Mallory, kindly note these next words, there is a bona fide litigation respecting the title of that representation. Amongst other, that reason of the thing seems to be this, that though a man makes a will, he appoints an executor. Yet, if the executor be under any incapacity or disability of acting as such, he is during his incapacity, in any respect, is no executor. Therefore, for that time, it is considered as an intestacy. For that time, it is considered as an intestacy. My lord will kindly thereafter has paragraphs 52 to 54. Oh, Muller, I'm told Muller has a fixed matter. Muller, will kindly make a note of the paragraphs of this judgment, para 52 to 54, and thereafter 65. Eh? 52 to 54, and thereafter 65. Muller, here also, Muller, there were executors named in the will. The Honorable Court appointed an administrator pendentility despite that, in the facts and circumstances of this case. In my case as well, my lord, I have established at least prima facie, my lord. My lord has para 52 to 54 and thereafter 65. My lord will kindly make a note. I'll, my lord, not read out the entire judgment, my lord. And 73, 75 is the final decision where, my lord, the administrator is appointed. Here also, my lord, there was a bona fide suit or other bona fide proceeding wherein, my lord, we are contesting the proceeding and the entire circumstance behind both the will and the subsequent dissipation of assets is clearly established from the dates that I have shown, my lord. 52 to 54 is the ratio, and thereafter 73, 65 and 73. Judgment 50. My lord, we kindly have a note of the paragraphs, my lord, 52 to 54, 65 and 73.
54.
52 to 54, 65 and 73. 73 and 75.
Yes.
My lord, those are my submissions, my lord. That's all.
Any date your lordship may fix, your lordship. I'll complete myself.
Learned advocate for the applicant in GA3 of 2024 has concluded its submission. Fix. Thirtieth July next week.
30th July.
2025 for submission.
Lordship, any date after 1st August, your lordship. Any date, your lordship.
GA3. My lord, submissions I've concluded in GA3 only.
Yes,
GA4.
GA3.
My lord.
Applicant in GA3.
My lord.
Fix 6/8/2025 for submission by the petitioner in TS5 of 2010.
Only one report I am seeking for, your lordship. The earliest erstwhile advocate on record, your lordship, has expired. So I'm praying, your lordship, that Wakalat Nama, your lordship, be filed, your lordship. Your lordship, kindly grant me leave.
Okay, leave is granted to file Vokalatnama on behalf of the petitioner executor.
Yes, your lordship. I'm grateful.
One fixed matter, item number 3, under heading to be mentioned.
Before
Lord,
Lordship takes
before
up the
my
fixed
learned
matter,
friends-
Lord, it may take some time. Lord, next matter is mine. Lord, only thing.
Which
is
item?
Item 16 and 17, Lord, both together, Lord. Now, Lord, only thing Lordship is division bench at 2 p.m. Whether
Yes.
this court will sit after 2 p.m. or Lord, this is.
So I don't know how long that will go. So it's better it will be taken up tomorrow.
No, let it be there in the list. I do not. It will take only 2 minutes time, Lord. Only for compliance of court's order, Lord, I have to file a compilation. If this can be recorded and Lordship can fix the date, Lord.
Okay. Item 15 and 16. Shall I keep it next week?
Lordship will pass an order, Lord, recording the fact that I am filing the compilation on behalf of the defendant. This is
Better. 15 and 16, let these matters appear. Okay, let this matter.
Lord, only thing, Lord, let the compilation be taken on record. There was a direction by your Lordship on 1st of July that you file a compilation report, Lord, of the 2 reports filed.
Okay, item 15 and 16.
16.
Okay, item 16 and 17. Okay.
16 and 17.
Same order হবে. Learned
Appearing on behalf of the 20 petition.
The
Item number 16 and 17.
filed by learned
defendant,
advocate for the defendant in defendant be kept with the record. Yes, when you will file the compilation? Fix.
May I be permitted to make my submission?
subject to the court's convenience.
Okay. Fix 5/8/2025 for hearing of the case and filing compilation by the plaintiff.
Lordship has recorded that defendant has filed.
Yes. You are the sole defendant.
Yes, sole defendant. Notes of argument have also been.
Lordship, may I be permitted to very short submission?
No, I've kept it on 5th of August.
Okay.
Sorry for the inconvenience.
Yes.
My lord, before my learned friend starts.
Yes, which item, Mr. Ghosh?
My lord, there is a
To be
fixed at
mentioned, item
12:30.
number 3.
Item number 3 fixed at 12:30, my lord.
Item 3.
My lord, before my learned friend starts, my lord,
It
one
will
thing I am
take some
saying.
time.
No, my lord, there is no time required. I have
I'm
filed
trying,
my
that
notes.
I was under
It's only-
medication.
It's only a question of
Today,
transfer.
only for this matter I have come to court. Because your lordship have specially fixed this matter on 12:30. So let my learned friend will
Yes, yes,
start,
let Mr. Ghosh start.
and I will come back another day. I will.
My lord, I have already made my submissions. Kindly, my lord, take the written notes of
Yes.
argument once, which is filed. Today, my lord, also there is no notes of argument on their part. So, my lord, that is closed chapter because it was peremptory direction. Kindly takes my written notes on submission.
Yes.
My lord, kindly, my lord, see the nature of the suit. Instant suit was essentially being instituted by the plaintiff for recovery of area rent and/or occupational charges accruing on part of the defendant, State Bank of India, for the occupation of the premises for the extended period from 1st May 2014 till 30th June 2014, after the expiry of a lease of 21 years pursuant to the lease agreement dated 17 September 1996. So, my lord, initially there was a lease agreement that expired after 21 years. Thereafter, State Bank and the plaintiff had entered into another agreement. Kindly come to B, cause of action in the present suit. The cause of action arises in the present suit on the basis of an agreement dated 25th April 2014. This your lordship will find at page 27 of the plaint, whereby the defendant is allowed to temporarily occupy the said premises at 36 Chowrangi Road for an extended period of 2 months, commencing from 1st May 2014 till 30th June 2014. As per the terms and conditions of the new contract dated 25th April, the defendant had to pay an amount of 4 lakh per month as rent and an amount of rupees 7 lakh 65 per month to the plaintiff as service charges for the additional 2 months of temporary occupation.
No objections raised.
No objection raised. The defendant had agreed to the new terms. During the said temporary period of occupation, the defendant had failed to pay the rent and other additional charges to the plaintiff, which has amounted to 33 lakhs. However, the defendant had continued to occupy the said premises after the expiry of the said additional 2 months. During the said period, defendant had failed and neglected to pay the occupational charges. Now, see, this is the contention we are concerned with now. It is stated that the suit is essentially based on commercial agreement dated 25th April 2014, issued by the plaintiff in favor of the defendant after the expiry of lease. The agreement be it in writing and also being an agreement in relation to any mole property, exclusively being used for trade and commerce, comes within the ambit of commercial dispute. So, well, State Bank is obviously had been using it for their trade and commerce banking, and it is a written agreement. Therefore, the instant suit is liable to be transferred under provision of section 21C7, which deals with this provision of the commercial division. However, the cause of action in the suit arises from the agreement binding the parties on the amount of unpaid debt. Transfer, now D, transfer of suit to commercial division where cause of action does not arise from notice of termination. My lord knows, my lord, Deepak Polymer's judgment is there, which my lord.
So the division bench
Yes.
matter was pending in the
Pending,
division
but
bench.
my lord, that is in case where the lease is terminated by 106 notice. Our case is not that. Our case is clear. Is after the lease has expired by efflux of time, parties have, my lord, entered into fresh agreement. What would be the quantum under that? There is no question of eviction. No question of eviction, nothing. No 106. So, my lord, I say, my lord, kindly now, my lord, turns over the page and my lord, come to 3. Section 15(1) of the Commercial Court Act reads as follows. All suits and applications, including applications under the Arbitration and Conciliation Act relating to commercial dispute of a specified value, pending, kindly marks this word, pending in a high court where a commercial division has been constituted, shall be transferred to the commercial division. It is clear that as on the date of notification of Commercial Courts Act, if any suit of commercial nature is pending in the High Court and the commercial division has been constituted, the suit will automatically be transferred. It is stated that the wordings used shall be transferred to the commercial division makes it amply clear
that a commercial dispute falling under 2(1)(c) of the Commercial Courts Act shall have to be mandatorily transferred to the commercial division. Moreover, the question of transfer under 15(5) applies only if section 15(1) is not implied. Hence, we may conclude that 15(1) is also an accepted mode of transfer of pending suit suo motu by a competent court. Conclusion, instant suit should be transferred to the commercial division under section 15(1) after adjudicating the disputes, for adjudicating the disputes. Simple case, my lord. This is not a 106 notice scenario or termination. The new agreement between the parties is clear. All I am saying is that the suit is for recovery of money, of arrear rent. Simpliciter, no 106 notice. Simpliciter, this is a suit which was pending, being a 2014 suit which was pending when the commercial court came in. 15(1) clearly says if a commercial dispute is pending.
What is the decision? This Polymer's decision?
My lord, the Deepak Polymer's decision is there. But trust me, my lord, kindly takes it from me. Deepak Polymer has, my lord, nothing to do with this.
You have relied upon this?
No, I'm not. I've just said that this may be argued by them. Just to, my lord, obviate that. And my lord, Lakshmi Polyfive is clear. That judgment I have not included in the note, my lord. I can just hand up to your lordship. Although not required, my lord, 15(1) is clear. But Deepak Polymer is only in case of 106, where the division bench has held, court has held, that since 106 is a statutory remedy under Transfer of Property Act, so it will not come under Commercial Act. But kindly seize my plaint. My plaint case is nothing to do with 106.
Recovery of money only.
Yes.
Simpliciter.
Under a commercial contract. But I do not know why my learned friend is even objecting. But
What is that other judgment?
My lord, this is the Lakshmi Polyfive, my lord, paragraph 69. This is my lord.
This is
Reported in my lord.
2021 to CLT page. 2021 volume 2 Calcutta Law Times page 240.
You have a copy?
Yes,
I
yes.
have a copy. Volume 2.
এটা হচ্ছে বলে দিচ্ছি আরেকবার 2021 to Calcutta Law Times 214. Lord, paragraph 69, your lordship will read from paragraph, kindly read from paragraph 69 to 73. To 73. Kindly takes for 71 once. I'm not troubling your lordship with the entire thing. Just kindly takes paragraph 71 once. Section 15 has required the transfer of pending suits and applications relating to a commercial dispute of the specified value to the commercial division of a high court. Section 12A of the Act of 2015 has stipulated a pre-institution mediation. Reading the three sections, namely 7, 12A and 15, together and interpreting the three sections in strict narrow sense, as in Ambalal Sarabai, has required a court to give a narrow and strict interpretation to the provisions of the 2005-15 Act, then it cannot be said that that there is interportability between ordinary original civil jurisdiction of the High Court and commercial division of such High Court. A suit which has been filed subsequent, kindly marks this, subsequent to the notification of the specified value in the ordinary original civil jurisdiction of High Court cannot be transferred to the commercial division of the High Court by virtue of section 15(1) of the Act. So, section 15(1) can be pressed into service if it's
pending cases.
Pending. But once it is after the coming in of the Act, it cannot be transferred. This is clear. Lord, we are making this sort of prayers. In fact, Justice Shugata Majumdar, sometimes my lord himself fishes out these matters and tells us that this is commercial suit. Justice Krishna Rao also does that. Because this is no application, no formal needs to be made. Pending suit, your lordship only has to see what is the subject matter. If the subject matter, your lordship appears to your lordship as commercial, it has to be transferred, my lord.
Anyway, give a copy.
Yes, my lord, I'll make a copy and give it to your lordship's officers today only.
My lord, I will come back next week.
Yes.
Next week, when you copy.
Well, Lakshmi Polyfive copy that. Well, may I take back that book?
Learned advocate for the plaintiff concludes submissions with regard to the transfer of this matter to commercial court. learned advocate for the defendant is to submit with regard to the transfer. Let this matter appear on 2nd August 2025.
Second. Well, kindly fixes the time. My learned friend is not.
It's a, there
Is not
will be
well.
there will not be much matters because it's a working Saturday, okay? So you take your chance, your matter will reach.
My learned friend is not well. That's what he indicates. Will he come on that day?
I'm keeping it on
Again,
2nd
Malad, I
of
will
2nd of
come,
August.
and then
Please
the
come.
prayer is made that he's Malad, not indisposed.
No,
On a
long time.
Saturday.
I think he will recover himself. By the grace of God, he will recover.
Let's all pray for that.
Yes, 2nd of August, working Saturday.
I'm grateful to my.
Waiter either.